All right, we'll get started here real quick. I'm just going to say hello. I'd really like to thank all of the speakers, the commentators, the moderators for coming out today. We're really excited about this year's symposium, Inclusion, Exclusion, and the Administrative State. And I'd just like to say thank you on behalf of the Duke Law Journal. Professor Adler will give some introductory remarks.
Thank DLJ for holding this symposium. Let me thank the panelists for a really wonderful bunch of papers. Looking forward to discussions today. I'm not going to comment specifically on the papers. Rather, I'm just going to briefly, try to get this done in 10 minutes or so, say something about equality and the Equal Protection Clause that I hope will put the papers in a broader frame and raise some broader questions which are worth considering. Now, these papers are generally about administrative agency interpretations of the Constitution, specifically the Equal Protection Clause, and the extent to which agencies can engage in more expansive interpretations of the Equal Protection Clause than the courts. Frankly, I don't think it's likely, I'm happy to be proved wrong, but I don't think it's likely that administrative agencies under the President Trump administration will in fact be adopting expansive interpretations of the Equal Protection Clause. So that raised the question, why are we doing this? And I think this is a question lots of law professors are asking about lots of work. One of my friends said that what we're doing now is sort of like the monks in the Dark Ages. I hope that's overstated. I hope that's overstated. And in any event, I think what we're doing is very, very important. Okay, so let me distinguish two concerns about inequality, or two sort of ethically relevant types of inequality, or ethically problematic types of inequality. Let me call them inequality in the anti-subordination sense, and inequality in the unfair distribution sense. Now, inequality in the anti-subordination sense is, I think, very familiar to scholars of constitutional law. A concern with anti-subordination is, I think, and I think a lot of people think, is the best understanding of what drives the court's suspect class doctrine, at least its doctrine concerning sort of the paradigmatic suspect classes like gender and race. That is, the concern is that there are groups that are historically subordinated as a matter of social practices and understandings. They've occupied the position of a subordinated or a lower status group, and the concern of the doctrine is to address that. Right? The concern of the doctrine is to address that. Suspect classes are just those groups that historically have been subordinated in one or another way, and doctrine is about correcting that. At a minimum, doctrine gives strict scrutiny to laws that facially discriminate against those groups, because such laws are likely to be unjustified and sort of expressively count as reinforcing subordination. Doctrine may go beyond that in ways that anti-subordination theorists might think is problematic. So, for example, doctrine might strictly scrutinize even benign as opposed to facially invidious discrimination, but still the underlying concern is anti-subordination. And this has obviously been a live part of doctrine in the sense that suspect class doctrine, race, gender, has generated lots of case law and lots of invalidation. But I want to raise a different kind of inequality. Let's call this, I've already called it the fair distribution type of inequality. That is inequality concerned with the fair distribution of goods, right? In particular, a concern for the fair or unfair distribution of income, right? And for that matter, other goods, other components of well-being. So, for example, concern for the distribution of health or of life expectancy or happiness. Or more abstractly, we might think about a concern for the inequality of well-being, right? Now, this concern here is not so much, again, about the subordination of particular groups, but rather about the population-wide distribution of income, health, longevity, life expectancy, or well-being more generally. So why care about that, right? Well, let me just make a couple points, which I think, again, should be obvious to anyone who's been not under a rock. Inequality of well-being, or at least inequality of income, has increased massively in the United States since the 1980s. That was first documented by the now famous Thomas Piketty and worked with Anthony Atkinson, a very great British economist who unfortunately just died. I'm very sad to say that in early January, two of my great heroes, Tony Atkinson and Derek Parfit, two great minds, died. But Piketty Atkinson has documented the incredible increase in income and wealth inequality, particularly in the U.S. since the 1980s. They're the ones who coined the term the 1%, because they focused on the disparity between incomes in the top 1% and the rest of the population. And this academic concern in turn sort of migrated to popular discourse, to political theory, right? So this concern with income inequality or well-being inequality, is part what motivated Occupy and was picked up by Sanders, and it's been a topic of great discussion. So it's a different kind of inequality, and again, something which, like anti-subordination inequality, is of serious normative concern. Let me just make two parenthetical points here. One is that a concern for the inequality of well-being, I'm going to say well-being, although typically we measure this in terms of income because those are the most available statistics. But a concern for the equality of well-being or well-being goods such as income is not just a concern for poverty, right? I mean, one interesting point to note is that poverty or income poverty, right, this is the percentage of people below income threshold, has actually gone down or at least been stable since the 1980s. Now, of course, the fact that it hasn't gone down much since the 1980s is itself a scandal, I think. But what's really gone up is not poverty, but inequality. Right, that's what, if one looks at the population-wide distribution, again, of income using things like the Gini coefficient and so forth, what's gone up dramatically is inequality. In a way, poverty lies at the intersection of the anti-subordination concern and the inequality concern, in the sense that the poor are both a kind of subordinated, stigmatized group, and that increased poverty is just one aspect of increased inequality, population-wide inequality more generally. The other thing to note is that a concern for income inequality is not the same thing as a concern for positive rights. I mean, one of the terrific papers here talks about positive rights. So a view that a right is positive is to say that, the rights holder is entitled to government provision, to some kind of positive government assistance, right? So one might have the view, for example, that a certain substantive right constitutionally requires state funding. So, for example, one might have the view that the right to contraception requires state assistance if one can't afford contraceptives, without thinking that the Constitution more generally is concerned with wealth inequality. All right, so this is the question. I'm not going to answer it, but I think it's useful to have this in the back of our minds as we read these papers, which are largely, although not exclusively, concerned with inequality in the anti-subordination sense. So here's the question. In this age of increasing distributional unfairness, how should constitutional law, either as applied by the courts or by agencies, take account of both non-subordination, right, and inequality in this other sense of distributional unfairness? Now, again, I'm not going to answer that, but I want to just get that out there and have us thinking about it and thinking about it for the next 4 years. Let me just a couple points to note, and then I'll stop. So one is a doctrinal matter. Let's be clear, wealth is not a suspect class. Wealth is not a suspect class, right? My con law students or some of my former students have heard me say that. Although the court, just a reminder, right? The court in some cases from the 50s and the 60s seemed to suggest that wealth was on the verge of becoming a suspect class. So, for example, Griffin against Illinois from 56, Douglas against California from 63, or Harper against Virginia Board of Elections, 66. So, for example, Harper, the court said, quote, lines drawn on the basis of wealth or property are traditionally disfavored. Okay, by the 70s, the court had decisively rejected that. So the rejection of the suspect status of wealth discrimination is often tied to the San Antonio against Rodriguez case, right? Well-known case that upholds Texas' use of local property taxes to fund education. In the course of doing that, right, the court at length explained why there was neither a suspect class nor a fundamental interest. But in the course of that long analysis, the court says, this court has never held that wealth discrimination alone provides an adequate basis for invoking strict scrutiny. When I teach this stuff, I actually find the James against Valtierra case an even more striking statement, articulation of the doctrinal position that wealth is not a suspect class, right? Because James involved, from 71, the most explicit wealth discrimination to which the court gave not even rational basis scrutiny, but no scrutiny at all, right? So James, remember, is a case in which California, the good citizens of California, decide to put in place a special hurdle in place before the approval of a low-rent housing project. And so there's a provision in the California Constitution that says any low-rent housing project has got to go through this special hurdle, right? And low-rent housing project is defined as the term low-rent housing project shall mean any development for persons of low income, right? And persons of low income mean persons or families who lack the amount of income. So the most striking and invidious, not benign, but sort of putting a special burden on persons of low income, and the court gives no scrutiny at all. That's doctrinally. Let me also say, as a matter of general public law doctrine, there's no general public law principle that agencies should take account of distributional inequality. Many of us hoped when Obama came to office in 2009 that the cost-benefit order, you know, there's a general executive order, 12866, requiring agencies to engage in cost-benefit analysis. Many of us argued that that should be revised, or at least the guidance under that should be revised to encourage agencies to take account of equity, right? And I and others sort of said specifically how that might be done through various metrics of distributional unfairness. That did not happen. That did not happen. And so cost-benefit analysis now, as 8 years ago, remains insensitive to distribution. Okay, so let me, just 2 minutes and then I'll stop here. So there are two questions here. One is the ethical question, which is about how they relate, right? How do these two concerns relate? Concern for anti-subordination and a concern for fair distribution. I mean, one view, sort of welfarist philosophers might say, at the end of the day, it's all about distribution, right? Being subordinated is just like, you know, having low income or bad health. It's just one of the characteristics that produce low welfare, right? So it's all about distribution. I think anti-subordination theorists are likely to object to that, right? They're likely to think that subordination has some sort of distinct ethical status. The opposite extreme might be to say that subordination kind of takes lexical priority over fair distribution. So first and foremost, government must not subordinate. And then, within the constraints policed by that requirement, government's free to sort of redress wealth inequality. Again, if one thinks about it, it's not clear that that's right. I mean, let's imagine that government can act to redress gender or racial disparities to some extent, but at the cost of a large increase in population-wide inequality of income. Should it do that, right? Is it really true that any step to redress subordination takes priority over any step to redress inequality? So finally, there might be kind of balancing. How to do the balancing is really hard. The other question, which brings us back to the stuff today, is institutional, right? Once one has worked out how inequality in the distributional sense relates to inequality in the subordination sense, how does that sort of play out institutionally? And there are really two different questions here. One question is the kind of question that we're familiar with, namely, is this concern for fair distribution judicially enforced or not? Another question is this just the concern of tax and transfer bodies? So should we think that it's simply the income tax system, you know, and the welfare system, the system of money exactions and payments, that should be concerned with fair distribution, or do we think that all regulatory bodies should be concerned with it? So just to give my 2 cents, I'm skeptical that courts can enforce it, but I tend to think that this is something that agencies, across the board should be concerned with, not simply agencies that are part of the tax and transfer system. Part of the reason for that is that, again, at the end of the day, our concern should not be just for the distribution of income, but the distribution of well-being. So, for example, if some people have much lower life expectancy than others, right, that too is a kind of unfair distribution. And part of the point is that the characteristics that lead to maldistribution of non-income goods might not be taxable. Right? It might be that some people just have a lower life expectancy because of a bad gene. Right? It's sort of odd to think that the tax system is going to give them subsidies based on that. Right? So it would seem that, for example, the EPA has to take account of distribution of inequality and not just the IRS. Indeed, that's why I argued that the cost-benefit order should be revised to do that. All right. So just to sum up, questions, not answers. That's what legal law profs get to do. But to summarize what I've been saying, in this age of massive, and unfortunately the evidence is it's going to increase unless we have a big tax rise. I don't think we're going to have that. But in this age of massive income inequality, we need to start focusing not just on what the Constitution requires with respect to anti-subordination, but also what it requires with respect to fair distribution. In reading and talking about these wonderful papers and extending this very important Constitution outside the courts project, let's have that as one of the things in our minds.
All right, Matt, that was a wonderful introduction, and I think it sets up intentionally, but also fairly effectively, this panel quite well, because I think in many ways it points to two of the interesting innovations of this panel. It might be the case that the anti-subordination doctrine for the 21st century is doing a lot less work than it ought to do, and that we ought to think about a different framework for dealing with the large question of inequality. And it might also be the case that we ought to be turning more towards institutions, in particular administrative agencies, to help us think through the problem of inequality in a way that can be much more effective than the 20th century model. And I think part of what this panel promises is to help us to think about these questions and with respect to two specific domains in a way that is both fascinating and interesting. I'm not going to take a very long time to read the bios of both of our authors and commentators. We have Professor Collins, we have Professor Johnson, we have Professor Mendelson, we have Professor Abrams, and each of them are absolutely amazing academics in their own right. Their bios are in your booklet. You should familiarize yourself with them, but more importantly, you should familiarize yourself with their work. I know that I've been inspired by their work, and I know that you will be as well. The authors will take 20 minutes each to present their papers, and the commentators will each take 10. And did I just give you more time?
Yeah.
Oh, okay.
I mean, I'm not going to take all that time.
All right, that's fine. Then we'll also have more time for engagement. We'll start with Professor Collins, if that's okay, followed by Professor Johnson, and then Professor Abrams will comment on Professor Collins' paper, and Professor Mendelson will comment on Professor Johnson's paper. Is that right? Okay.
Thank you.
Does that work?
We're going to do, doing paper comment.
Would you prefer to do paper comment? That's fine. All right, paper comment.
It doesn't matter to me, but I just
Excellent. I don't mind going,
comment so that people don't forget.
changing on the fly.
Just to go over the content of the papers?
Paper comment.
Okay.
Excellent.
All right, great. Now that
Thank
we
you.
have those administrative details settled, let me
Thank
just
you.
get a clock up so that I know where I'm at in my time.
I'll help you.
Will you help me? Oh,
Yes.
thank you. Okay, great. Okay. I want to begin also by thanking everyone here, thanking the organizers who originally conceived of this symposium and for inviting me to participate, and also for the hard work of the Duke Law Journal editors and their superb organizational efforts. I want to start slightly differently than I was going to, just to respond to some things that Professor Adler said and to frame my paper in some of the terms that he used in the spirit of conversation. So several of the papers, I think all of the other papers actually, do explore how agencies have engaged in expansive interpretations and implementations of equality norms. And I have to say I'm probably the bad news bear here. My story is really one about how agencies have narrowly construed conceptions of equality, but actually more accurately how their conceptions of equality are historically situated and determined in some senses by, obviously by reigning social and cultural norms. And I'm also not directly speaking about distribution of goods along as assessed by some kind of equality metric. Immigration and citizenship status is the subject of my paper. And so if you think about citizenship as theorists have called it, is the ultimate right to have rights, right? It's the entryway. It's the entryway into a world of rights, at least in the world order that we have today. But I will say that it's also correlated strongly to one's life's chances, what citizenship you hold, and can you get through that door? And in that sense, and in the sense of global inequality, I think it absolutely fits within the themes raised by some of the other papers. So I think in terms of a symposium that is concerned with themes of inclusion and exclusion in the administrative state, one cannot find a more obvious example than in the papers of the administrators who I study, sometimes obsessively. And these are the officials who implement immigration and citizenship law. I want to risk disappointing you from the outset by saying that my paper, which is called Bureaucracy as the Border, is not about President Trump's executive order issued 1 week ago today. Had I been so prescient as to write such a paper before the orders were actually issued, I would be happy to publicize as much today. But Bureaucracy at the Border, as the Border, is about the origins and durability of a set of gender-based and birth status-based family law principles that continue to animate our citizenship, naturalization, and immigration laws. So my paper presents a micro-study of the laws that govern the parent-child relationship for purposes of immigration and citizenship and also naturalization status, with particular attention to how and when those relationships are recognized when the child is born outside of marriage, which of course is an increasing phenomenon globally. Stated simply in American law, those statutes have virtually always recognized the relationship of the mother and the child while limiting recognition of the father-child relationship in various ways. The modern-day versions of these statutes have been subject to 4 challenges at the Supreme Court in the last 2 decades, and in 1977 was the subject of a sort of canonical immigration law case called Fialo versus Bell, which reaffirmed the plenary power doctrine, which is basically like a hands-off judiciary doctrine, sort of similar to an abstention doctrine. Now, one question I ask is what accounts for these laws' durability, these gender and illegitimacy-based laws or classifications, if one wants to use that language, for over a century, even in the face of seismic changes in how we understand gender role, how we understand illegitimacy and birth status, not just in law, but in our everyday lives. It's tempting to focus on the Supreme Court's role in upholding these laws, in offering a causal explanation, and generally it has upheld these laws. There is a case pending right now, and it may go the other way. Who knows? But without at all suggesting that what the Supreme Court will do, has done, may do, is unimportant, because I don't think it's unimportant. I do think that if one wants to understand the development and survival of these laws, one must turn to the administrative sources, and I mean deep into the administrative sources. So I asked 3 questions here. First, how did these particular lines using family law develop within our citizenship and immigration laws? How did they take shape? Why are the lines that were drawn by administrators over 100 years ago still the laws that we have today, and why the ongoing challenges? I just mentioned 4 cases at the Supreme Court, but you can go into the BIA records, into the lower court records, and you'll see much more. In addition to the cases that just simply are never adjudicated. All right, and then what does this tell us about administrators' roles as lawmakers? On the how and why, I don't want to offer a monocausal explanation here for why these gender-based laws came into being, but I do think that the administrators played a primary role in cultivating family law norms that would govern the children's citizenship and immigration status. And they did so not in flashy, dramatic executive orders of the sort we've seen recently, but in interdepartmental memos, in intra-departmental communications, in cables and airgrams. This is the routine work of administrators every day. The administrators I write about are the mid and high-level officials in several of the key departments in the early 20th century and late 20th century. The Department of State, the Department of Justice, and the Department of Labor, which housed at that time and up until 1933 the Bureau of Immigration. Of course, we know that administrators engage in different kinds of lawmaking. Jerry Mishaw, following the early 20th century administrative law scholar Bruce Wyman, have written about the development of, quote, internal administrative law. The agency created policies, rules, procedures that guide administrators' decision-making on a regular basis. Jillian Metzger, who's here, Sophia Lee, Karen Tani, who will be joining us by Skype, have written about administrative constitutionalism, the process by which administrators, largely through implementation and statutory construction, elaborate and realize constitutional values and norms. But immigration law is often considered a separate and exceptional regulatory domain, one that is especially lawless in its parameters and operation. One immigration law scholar described the field as, quote, radically insulated and divergent from those norms of constitutional right, administrative procedure, and judicial role that animate the rest of our legal system. So one thing I want to do with this paper is to bring immigration and citizenship law back into a conversation about administrative norms and administrative lawmaking, and recognize the processes of lawmaking there, while also enabling us to subject those to some kind of critique, okay? If one examines the work product of administrators on the ground, as I have, a different picture emerges, not one of lawlessness in the absence of law, but it was, and as a ministrect is, a law-filled world, filled in this case with family law, or the administrator's understanding of family law. As I said, my focus is the parent-child relationship, and in particular, but not exclusively in this part of the project, the father-child relationship. And the primary difficulty for early 20th century administrators was generated by what we call today the derivative citizenship statute. And it recognized some foreign-born children of American parents born abroad as citizens at birth. Easy reference point, Ted Cruz is an example of this phenomenon today, okay? But until 1934, it was his mother who was the U.S. citizen. Until 1934, it was only fathers who could transmit citizenship in this way. And administrators implementing the statutes were thus confronted with the problem of statutory interpretation. What is a father? And this was an easy question to answer if the parents were married. But if the parents were not married, it was a much more challenging question, because under the common law, the recognition of the father-child relationship was practically impossible outside of marriage. Okay, so that was a baseline norm. The 1920 case of William Oppenheimer is illustrative of this problem. He was a child born in Guatemala of an American father and a Guatemalan mother. Her name, unfortunately, I do not know because it is not reproduced in the record. The parents were not married. Since 1900, so at least 20 years at that point, the Department of State had been recognizing the, quote, legitimated, and this is a legal term, legitimated children of American fathers as citizens, as being brought within the statute. But first of all, this was a departure from the common law. Under the common law norms, even if the parents married, the child was not recognized. Secondly, and this to make matters more complicated, the states at this point had developed these things called legitimation by acknowledgement statutes. There were various ways that a father could legitimate the child, and William's parents had never married. Instead, the father had, quote, legitimated the child through a Louisiana legitimation statute. In William's case, the Department of State, and actually his case was clustered with two other cases raising similar issues, and the Department of State forwarded the cases to the Attorney General's office to get an opinion, a legal opinion. What was the status of these children? Could they be recognized under the statute? And the Attorney General issues an opinion in 1920 saying if the child was legitimated under the law of the domicile, then the person is legitimated and the child is a citizen. And under this standard, William was a citizen, as were the two other children involved in their cases. But there was an important exception at the time. Importantly, but unsurprisingly, the interpretation of the derivative citizenship statute in cases involving ethnic Chinese children was different. Administrators who were charged with the task of enforcing these Chinese exclusion acts, of which you will be hearing much more, I suspect, and learning much more about in the coming months, as an important sort of historical precedent for some of the things that are happening now. But the administrators at that point largely rejected this conception, this broader conception of legitimation in derivative citizenship statutes, cases involving the children of American fathers who were of ethnic Chinese origin, a phenomenon that actually was much more common than you might think. I'm happy to expound on that after in Q&A. In these cases, administrators found that no process of legitimation could make the ethnic Chinese child of an American father a citizen. In this racially hostile environment, then, family law served as a tool of racial exclusion from the polity. Now, standing alone, I don't think that administrators, and having read a lot of their memos, they were not worried about differential treatment of ethnic Chinese children in and of itself. The worry for most administrators, I think, was that many of these, especially the Bureau of Immigration, their primary task, the mission of the agency, was dominated by the enforcement of the Chinese exclusion laws. The discomfort for them was not what we in hindsight would see as the sort of ethical or moral discomfort, rather the discomfort for them was a disjunction between the 1920 Attorney General opinion and the appearance of instability in the internal administrative law that they had developed. It was also that same sense of anxiety as apparent in memos that reveal their interpretation and application of the statute that I've just described, which only applied to fathers on the text of the statute. And yet they extended it to include the non-marital children of American mothers born abroad, born outside of the United States. The anxiety surrounding these interpretations was evident, as I said, in their memos, and it was also evident in the fact that they turned to Congress for help, for a new statute, starting in 1906, really. But Congress does nothing. And so soon, the administrators decide to write a nationality code all by themselves, right? A full new code, right? Not just dealing with this particular area of law, but denaturalization. It's a full nationality code. And the precipitating event here was an executive order, a presidential order by FDR, who in 1933 directed administrators in the key agencies to write a new nationality law. They wrote an elaborate statute that codified exactly the principles that I just explained to you, and this was the Nationality Act of 1940, key portions of which were recodified in 1952, and in certain cases remains the law today. In fact, the case that's up in front of the Supreme Court right now, the statute that governs the individual citizenship is the 1952 Act. The process of administrative creativity did not end once the statute was codified. In the 1940s and 50s, for example, administrators hardened this conception of legitimacy and effectively interpreted in ways where to require marriage of the parents in order for the child to be legitimated and therefore recognized as a citizen. And this is pretty much where things stood until the civil rights period, until the civil rights era emerged. Cases up until this point, up until the 60s and 70s, cases challenging this statute and legitimation requirement were challenges to the agency's statutory interpretation, right? Their interpretation of a term in the 1952 or 1940 Act legitimated. What does that mean? But after the sort of rise of equality norms, different understandings of gender equality, illegitimacy, and challenges to illegitimacy classifications, not just in constitutional law with the sort of as enforced by the Supreme Court, but also in other agencies' work, in statutes, both state and federal. So I'm talking about broad shifts in our sort of legal fabric. After that shift, the kinds of challenges that were brought were not just statutory interpretation challenges, but as you can imagine, constitutional challenges, giving rise to, in 1972, claims by a group of fathers and children who were divided by nationality from their children, and filed the now canonical case, Fiala versus Bell, in the Eastern District of New York. These fathers were either unable or unwilling to marry the child's mother and therefore permanently separated from their children. And each story is a sad story. I'll just promise you that. You know, the mother's dead, can't marry the mother. Child has no parent, right? I mean, these are the kinds of stories that we hear. Their case went to the Supreme Court, which issued an opinion that reinforced the Chinese exclusion era doctrine, the plenary power doctrine, which I described earlier, a doctrine of judicial deference that establishes regulation of immigration as a field that is largely off limits to judicial review. After Fialo, Congress actually did take up this question, thanks to the good efforts of a progressive legislator named Elizabeth Holtzman. Her efforts, which were then later picked up, I'm doing a fast forward here, in 1980 by progressive legislators or liberal Democrats, Barney Frank and Pat Schroeder, generated a mixed result. And one reason, but by no means the only reason, that their legislative efforts were of only mixed results, was that at that point, administrators came into Congress and had basically a full court press against the gender equality norms that legislators like Barney Frank and Pat Schroeder wanted to have incorporated into the immigration and citizenship laws. So my purpose here, obviously, is not to grapple with the Equal Protection Clause question here. Rather, I'm focusing in on the story of the administrators, and I'll just close by making 3 observations. One, this is a story of administrators, most of whom were lawyers, and I think that's important, neither ignoring law nor necessarily following law, but creatively using laws to craft rules regarding political membership, both immigration status and citizenship. So there's a recent book by Adrian Vermeule, Law's Abnegation, and in that book, he describes a world in which the institutions that he thinks are the key legal institutions that establish law, the courts, have voluntarily surrendered their authority to the administrative state over time. My focus here is obviously narrow. He's painting in broader brushstrokes, and I'm providing a case study. But in my more limited case study, I do see some surrender, the plenary power doctrine. But I see this as less of a story of surrender than agenic behavior, of this process of creative lawmaking and doing so using family law, selectively taking from state family law. It is a creative act with both generous and inclusive dimensions, thinking of the non-marital children of American mothers who are included in the polity, and exclusion, the non-marital children of unmarried American fathers who are excluded. The implications of this disjunction between the legal status and the social status that these fathers and children will have and their status under citizenship and immigration law, I think, is important. Kerry Abrams, who will be commenting, and her co-author once described this very nicely. The same person who might likely be declared a legal parent under state family law, and I'll just add also a social parent, might also find himself to be a legal stranger to his child for citizenship purposes. And here I've described, I think, I'm arguing that I'm describing the origins of that disjunction, its evolution within the administrator's policies, and not so much in Congress. And I argue that this disjunction in status is at least one of the reasons why there's continuing litigation over this issue and dissatisfaction generally. Right now, 8 members of the Supreme Court, since we only have 8 members right now, are deciding at another equal protection case, as I mentioned. Questions of the scope of plenary power haunt this particular case, as they always do in this field of law. But if, and I'm just going to now end with some speculation, if the court strikes down the particular provision that's at issue in this case and strikes it down as unconstitutional, if that happens, the process is by no means over. It will just have begun again. And to the extent that there is a last word in these situations, in these processes, I suggest that administrators will be part of that conversation, right? For reasons I can explain, I will, especially in this case, I anticipate that there would at least be a good chance that Congress would take up this issue and and write new legislation to bring the statute into conformity with the court's ruling. That is to say, if the court strikes down the statute, and if that's the case, then I think the the Department of Homeland Security's, the Department of State, and the Department of Justice will be at the drafting table. And I'll just let you guys fill in the rest of that.
So thank you so much to everyone for having us here, and especially to Professor Collins for the wonderful paper. If you haven't gotten a chance to read it, you should. Like most of her work, it is refreshing to see such great detail in a case study that then opens up an area that we can think about more broadly. I was thinking about what kind of history is this as I was reading, and I thought, you know, this isn't history from the top down. It's not a Supreme Court history. It's pushing up against that. It's not history from the bottom up. It's history from the middle management bureaucrat, right? And it's an area that we haven't focused on as much that we need to. And it's also a history of regulation through the side door. So it's not the kind of regulation that we tend to see. It's not visible in Supreme Court opinions. It's not visible in executive orders or executive proclamations. But I think it's really where a lot of the action tends to be, especially in this area of immigration and citizenship law. I wanted to take my time to comment to think about the question, a couple of questions. One is this a one-off case, or is this something that happens more broadly within the immigration and citizenship area? And I want to answer that question by giving you a contemporary example of a similar dynamic that I think happens with cases that evaluate whether a marriage is bona fide or not. And then second, I wanted to move beyond immigration and think about whether this is a dynamic that we observe more broadly in administrative law in general, in the relationship between administrative and constitutional law. So starting with immigration in general, you know, many of you may know from watching movies or TV shows or talking to friends that if you're married to someone and you're a U.S. citizen, you may be able to get them immigration status, but that your marriage will be looked at much more carefully than most people's marriages are. And I think, like the story that Professor Collins is telling about parentage determinations, our marriage determinations are determined in ways that might be disturbing if they were brought as equal protection cases in the constitutional sense, but because they happen behind closed doors between a bureaucrat and an individual or a couple, we don't have access to seeing what kinds of determinations are being made. But they're being made nevertheless, and they may even influence constitutional decision-making when these cases do go up to courts or even the Supreme Court. So the way that the system works is if you are in a recent marriage, so a marriage that occurred within the last 2 years on the date of which you file for the visa, you don't get a regular green card if you're the spouse. You get a conditional green card. And then you have to decide, you have to demonstrate 2 years later that your marriage was bona fide. So one assumption built into the process is that a marriage that's not real isn't going to last 2 years. Right? So they're giving you a little bit of a test of time here. But there are also things that the examiners are looking for. The statute doesn't give a whole lot of detail. It just says that you have to demonstrate that it's bona fide. But the regulations give more. They give examiners a list of things that they should look for. This isn't a list of things that a couple has to have. They're just indicators, right? So that one of them is birth certificates of children born into the marriage. You don't have to have children to have a legitimate marriage, but if you do have them, they want to see the birth certificates. Other things include evidence of joint bank accounts, jointly owned property, jointly held leases, right? So you can start to see in the regulations the assumptions built into them about what a real marriage looks like, right? A real marriage includes commingling of funds. It includes living together in the same place. When I talk about this, law professors often get especially upset because they often are in commuter marriages and they don't have joint bank accounts, right? And so it doesn't look like their marriage. And so couples will try to conform to these standards if they have a lawyer who can tell them about them in order to look like they are the type of married couple that an immigration examiner would want to see. In addition to the regulations, there's also an adjudicator's field manual that goes into even more detail about what adjudicators are supposed to be looking for in these cases. And some of these things make sense, like has the person tried to sponsor a different spouse recently? Right? But some of them are more troubling. So, and you can understand the reasons behind these, but they don't always work out in actual cases in ways you'd expect. For example, one of them is there a vast cultural or linguistic or ethnic difference between the couple, right? And you can imagine where that came from. If you see someone who doesn't have a good reason for why they would have met someone else because there's such a gulf between them culturally, you might guess that maybe this was a marriage for money, for a green card, right? But in a lot of cases, the whole reason that someone is seeking the visa for their spouse is that they do come from another culture and they want to be together in the same one, in the same place, right? Or two people speak different languages but speak English together, but that is not the first language of either of them. Another detail in the adjudicator's field manual is is the spouse a friend of the other spouse's family? So is this potentially an arranged marriage, right? Now, there's nothing wrong with an arranged marriage for the validity of the marriage. And if we were to have a ban in a particular state against arranged marriages, you can imagine that case going straight up and the same court that decided Obergefell deciding it in a very similar way, right? But in that closed door where you're determining whether this is a bona fide marriage or not and there's no record of what happens, questions like that are completely on the table. So we've got the statute, we have the regulation, we have the adjudicator's field manual, then we have the practice that develops around all of this, and that's really hard to get at. So when I said regulation through the side door, it's like the side door that nobody even knows is there. And the best way that I've been able to get at that is by speaking to journalists who have interviewed immigration examiners, speaking to my students who have often been immigration examiners before law school. So think about that for a minute. A lot of the people testing these marriages are unmarried 22-year-olds, right? And also speaking to lawyers who advise couples about how to be successful in making these determinations. And the overwhelming evidence seems to be that the most important pieces of evidence that you need to demonstrate your bona fide marriage are pictures of a fancy honeymoon and a fancy wedding. So if you think about what our practice on the ground is actually encouraging, it's a very consumer-focused approach to marriage. It's hostile to arranged marriages, and it's hostile to interracial or interethnic marriages, and it's also hostile to marriages where there is economic equality and independence, right? So the law ends up tilting us in a direction towards a very specific type of marriage that may not actually be representative of the majority of the people seeking these visas to begin with. So I don't have a great way of tying this together with the Supreme Court cases the way that Professor Collins does with her parentage law, right? In the parentage cases, we see a direct link after reading her work between what the adjudicators did on the ground and then the way Congress decides to craft their statute and the way the court interprets it. But I do think we see some hints of a link in some of the recent cases. So if you think about the language in the Obergefell case about marriage responding to the universal fear that you'll cry out in the dark and no one is there, that sounds like a marriage of shared domicile to me, right? It's a very similar vision of marriage as to what you see in a lot of these adjudications. And in another recent case that came down 11 days before Obergefell, Kerry versus Din, which was a case that more on point where someone was seeking a spousal visa, there are curious references to facts in the Supreme Court opinion that have nothing to do with the outcome and yet seem to be influencing the justices. So the fact that the husband who was seeking the visa was a friend of the family of the wife and they had known each other before she had come to the U.S. as a refugee was tossed into the case in a way that feels to me like it's a suspicion of perhaps an arranged marriage or perhaps a different type of family structure than what the justices are used to seeing. So getting to my second point, which was about whether this immigration family dynamic exists outside of that very specialized and sometimes considered exceptional part of administrative law, I'll be curious to hear what some of the other panelists think throughout the day. But I would just say a couple of things. I suspect that this is a dynamic that exists broadly, but I also suspect that there are some details or some features of immigration and family that make it especially strong in this area. And there are two features that I would identify. The first is that immigration, citizenship, is an area of law in which all law has to be interpreted through a cultural lens. And it's being interpreted through a cultural lens in a space in which cultures are likely to clash. So it's very difficult to use these concepts of, who is a parent, who is a child, who is a spouse, in a situation in which we are essentially, what the government is trying to do is decide, is this a person that we want to be a member of our polity, without making judgments. And so the area is ripe for personal judgment and for cultural judgment in a way that some may not be. The second is that the law, as Professor Collins mentioned, is unusually open-ended. And I would say this about both family law and immigration and citizenship law, but in very different ways. In family law, the concepts are open-ended in that almost all of the tests are fuzzy standard kind of tests. The best interest of the child test. What's in the best interest of the child? There's 12 factors, and then there's always other, right? And so it's really, what does the judge think? Who does the judge think the better parent is? And a lot of family law is like that. And so Professor Collins has used the word pliable in some of her other work to describe how family law principles are so easily manipulated in situations like immigration determinations or citizenship determinations. But when you have these very open-ended concepts, it's easy for someone to insert their own cultural norm into the concept in order to interpret. Immigration law, on the other hand, is very clear-cut. The rules are clear, bright-line rules, but then there's always discretion. Right? And so it appears to be more clear-cut than it is. And so you have two areas of law that have a lot of room for discretion and interpretation coming together in a particular space where cultural judgments are likely to be really important. And I think that's a space in which we are especially likely to see this kind of on-the-ground agency determination becoming essentially the law. So in closing, again, not to be too depressing here, but I think we in the last week or two we've seen very much regulation from the top in a blunt and somewhat messy way, and we'll probably see more of that. We've seen judicial challenges to that regulation from the top, so we're going to start seeing equal protection claims, procedural due process claims, free exercise claims, all sorts of claims brought on behalf of immigrants. But even when that's over, no matter how it turns out, we still have this underlying system in which the regulation through the side door really probably is going to do a lot of the work. Thanks.
Thank you.
Good morning. So I'm Olatunde Johnson, and I'm at Columbia Law School. And I just want to thank all of you here at Duke and at the Duke Law Review for hosting this. It's lovely to be here, even if it's not your usual 50 degrees. We're happy. I want to say that to be honest, when Mila and Batral and others who are in this room, when we thought about organizing this conference, I at least, I think, imagined implicitly, perhaps not actively, a really different reality from what we have now. And I just want to speak to that a little bit before delving into some of my paper, because I came into academia from practice. I had worked as a civil rights lawyer, and I worked for Senator Kennedy on the Senate Judiciary Committee. And one of the things I was really struck by when I came into academia were some of the pronouncements about the state of equality law were actually much more dire in the academy than I thought they were in the world, actually. As a litigator, we were using statutes in really interesting and innovative ways, and I saw legislation that I'd never seen in law review articles that I had worked on when I was working on the Senate Judiciary Committee. And I thought of myself as a litigator and as someone who knew a little bit about statutes. What I soon came to see was really that the life a lot of the statutes that I cared about was really in the administrative state, and even more interesting things were happening there in terms of both administrative implementation of old civil rights statutes and new civil rights statutes. And so that's what I really started to write about in the beginning of my career as a law professor. And I want to say that all the while that I maintained a healthy skepticism about relying on administrative agencies alone. I think in the civil rights area in particular, we have what we call, from a scholarly perspective, often hybrid enforcement, right? So it's not just enforcement by administrative agencies. You also have the ability, in many cases, to bring private lawsuits. And in some cases, you have administrative agencies that have adjudicative authority. And so that leads to a lot of fragmentation in terms of civil rights, but it also makes it so that you don't have to put your eggs in any one basket. So I want to say that I maintain some healthy skepticism of it, but I think at least in thinking about some of the future and some of what was interesting about civil rights, probably put a lot of emphasis on administrative implementation and the notion of administrative constitutionalism. And of course now, I see how contingent it was, how tied it is to a particular moment. I didn't think it was contingent, but a moment when one could be really optimistic about the ability of administrative agencies to generate equality norms. And we sort of joked among those of us who work in this area that we were kind of technocrats for justice, right? So a lot of faith in technocratic administration. It's about the ability of administrative agencies. You see this in the work of Bill Eskridge and John Farragon to really respond to the civil society and some of the ideas coming from civil society, sort of deliberation. I want to say that this approach wasn't fundamentally partisan. Some of the statutes that I wrote about were actually implemented vigorously during the Bush administration. So this has to do with Title VI, which has to do with federal funds by the Department of Transportation during the Bush administration. There's a statute known that requires juvenile justice agencies to take into consideration disparities in the confinement of minorities and the rates in which they're in contact with the juvenile justice system, pretty vigorously implemented in the Bush administration. But still, I think a lot of this I see now is quite contingent. And since November, I've really been more pessimistic, as you can imagine, about implementation and norm generation at agencies. I worry, of course, about all those things that people worried about on the other side, those who are very skeptical of an administrative role in the first place, that there wouldn't be adequate enforcement and oversight, as well as concerns about administrative agencies and overreach and lack of reasoned decision-making. So that's all to say that, so when the election started, I emailed at my editors at Duke Law Review, and I was just sort of stuck. My piece was all about the future, and I think that future is really uncertain. Nevertheless, the point of the piece was really to think a lot about some of the recent actions taken on by the Obama administration and how they're raising concerns that seem to go in opposite directions. Are they going too far in terms of how we expect agencies to operate, both in terms of the strictures of administrative law and in terms of their substantive interpretation of the statutes? And I thought a lot of that obscured also some interesting things that the administrative agencies were doing under Obama that had to do with trying to, for lack of a better word, spur innovation in how we think about and how we implement equality. So in the time that I have, I was just going to talk a little bit, not so much about the critique of overreach, but some of what I was seeing in terms of promise and models. And I want to frame it by saying that my view for some time has been that there is an advantage of a kind of regulatory approach to civil rights that's different than the enforcement or adjudicative approach through private agency lawsuits. And this is not at all something that we should interpret as saying it's an either or, right? But it is to say that there are distinct advantages to a regulatory approach. And the advantages that I saw were that in the adjudicative or the private lawsuit approach, you're often approaching these questions from what we'd call kind of an ex post enforcement perspective, and it's very limited to a set of specified violations that we often think of as stemming from bias, maybe in some cases disparate impact. But what you see in the regulatory approach is an ability or at least a desire to take an ex ante or preventative approach and sort of look at what are the broader kinds of institutional changes that you can put into effect to spur inclusion. So that's the larger kind of framework that I'm coming with this. And so what we saw in the Obama administration was really an expansion of different aspects of this approach. And you see it in some of the things that have been very much in the press and some that have been less. So the implementation, for example, of the Department of Education of the famous Dear Colleague letter on sexual assault, a little bit less attention, but one on gender identity. They're really trying to ascribe a set of practices that are not just about resolving particular complaints, but are adopting practices to prevent or change, prevent sexual assault or change campus climate. I thought one of the most remarkable things was at HUD, okay, so this Department of Housing and Urban Development. I would have said, I mean, HUD has, of any agencies in terms of their civil rights capacity, it has one of the strongest set of administrative powers. It can resolve adjudication. It can do, which is just a dream. You would want that, you know, to be able to do private adjudication in the employment perspective. It has that power. It also has regulatory power, substantive regulatory power. Didn't exercise it for much of its history. And you saw just a rash, you know, a great amount of regulatory exercise and activity at the Department of Housing and Urban Development, most prominently in relation to the disparate impact regulations that went before the court, I guess now 2 years ago, and also the implementation of regulations to what are called affirmatively further fair housing, which is a statutory part of the Fair Housing Act, but never very well implemented by HUD. So I've long been interested in this, but the larger framework of using agency regulatory power. But in this piece, what I'm really saying is that agencies are going even further than the approach that we associate with things like conditioned spending and sort of rule promulgation. And so in the time that I have left, I wanted to provide some examples of that and lay out how we might think about this. So one thing I really saw beginning with the Obama administration is, of course, there's been this historic sort of reliance on grant programs, a long history in civil rights of relying on conditioned spending, but a real attempt to go further than just relying on the classic sort of stick approach, where you cut off federal funding when a regulated entity fails to comply with some predetermined norm or something that you have prohibited, but more of a kind of competitive grant approach. And the example that I give in the paper, I won't go into all the details, I mean, give a number of examples in the paper, but is a grant program that the Department of Housing and Urban Development, EPA, and the Department of Transportation took on that requires or that allows and supports initiatives that are trying to promote sustainable communities. And by sustainability, they mean a wide array of things, including economic inclusion and desegregation and racial integration. And so you see this reliance on competitive grants and not just sort of the stick of federal funding cutoff. A second aspect of this emergent approach that I was interested in is that the implementation of sort of a regulatory approach that collapses boundaries between agencies and within agencies. And by that I mean is the way we understand civil rights is often that it's this sort of complaint resolution in something called the Office of Civil Rights. But what we're seeing emerging is a kind of more pervasive set of requirements of civil rights or inclusionary requirements that we attach to a broader swath of programs. And so I see that as a kind of merging of the inclusion function that we see in the civil rights offices to the larger social welfare function of the agencies, and also collaboration, of course, across agencies. So I don't point this out for bureaucratic reasons. I mean, it's interesting for those who study agencies. But I think it's important for substantive reasons. I mean, we've known for a long time that some of the formalist anti-discrimination model is very limited because it assumes that people are similarly situated, that they face only those barriers of identity characteristics, and it doesn't address some of the more embedded forms of exclusion, such as differences in access to training or supportive resources, geographic exclusion, networks, social capital. It doesn't deal with all that. And it's resonant with some of the things that Professor Adler talked about. I mean, I think it's partly about fairness of distribution, but I think it's also that other line between sort of bias, discrimination as bias, and sort of more structural and embedded forms of exclusion. So these models have a way of getting at that, of the sort of limitations of the classic formalist anti-discrimination model. And then the third aspect that I was really interested in is how the regulatory model really draws on solutions that stem from the state and local level, and the sort of interaction between the federal government, which sets these sort of broad goals like integration, but leaves much of the details of how to implement those goals to the state and local level. Of course, there's been a long trend in moving in this direction in other areas of the law, but it's pretty anathema in the civil rights context, where the whole model is that you want a strong prohibition at the federal level. And so, but it's not unfamiliar in regulatory or innovation theory more generally. So, I was interested in this aspect of it. You specify the goal at some high level, like integration, and you specify the processes by which you might want to achieve that goal, but you leave all the details to states and localities. So I want to flag a set of concerns, and then maybe you can talk about them more. And I have a feeling that Professor Mendelson is going to talk about them. I'm really, I don't know what I think about it all in the end, right? There's aspects of this model that are really intriguing to me, but I'm fully aware of the limitation. And I just wanted to say a few quick things about the limitations, but let me just say one thing before that. I've been struggling with language, right? We call it civil rights. It often stem from the civil rights, from agencies and their civil rights offices, but really they're not in the rights model, right? They're actually about something like social inclusion, language of opportunities often in these regulations. My colleague Susan Sturm talks about full participation. And that to me is a real plus of them. They're trying to actually break down this notion that you're just trying to deal with identity exclusion. You're also trying to deal with economic inclusion. You're trying to promote opportunity among underserved groups. So I think that's a real strength. But I talk about them in terms of civil rights, but there's probably better language there. Okay, so what are the concerns? So, of course, the concern is that if relying on these models is going to produce a lot of variation. As it spins out, we're going to have really thick quality jurisdictions that are doing a lot, and we're going to have places that are just complying with baseline anti-discrimination norms. I do have some thoughts about that we can talk about that are pretty scandalous in the sense that for a civil rights person, in that I think that's happening anyway, right? I don't think this is any different from the reality, and maybe we should just find ways of subsidizing thick equality norms. So that's the most provocative way I'll put it. The second concern, which relates to that, is about accountability and oversight and where that's going to happen. I think the way for this model to work is that it doesn't just happen, obviously, at the federal level, although it has to happen more there, but it happens through political economy at the state and local level, so we can hopefully talk about that. And then third and lastly is really the biggest concern, which is what's going to happen to any of these things over the next few years. I don't want to make predictions. All of us said that we're out of the prediction game. But clearly, I think these things, they could either disappear, the ones that are guidance. Some of the pages that I've cited, I told the Duke Law Review, have disappeared already. I don't know even a full repeal doesn't happen. I think some of these things are not going to be effectively enforced, and obviously we can talk about that. So I want to leave it at that, and I feel like I didn't talk enough about the specific examples for people and assumed maybe too much knowledge, but maybe we can talk about that also in the Q&A.
right, good morning. First off, thanks to Duke and the Duke Law Journal for the opportunity to participate in this conference. It's a very engaging set of topics, and whether timely or not, I hope they'll be topics we'll continue to take up. And thank you to Professor Charles for a very gracious introduction and for his amazing scholarship. So Professor Johnson has just a really interesting paper on agency advances in equality law, agencies taking the initiative to examine issues that aren't anticipated directly by statutes or are perhaps not resolved directly by them. And of course, she gives lots of examples in the paper, whether those are transgender issues under Title IX or addressing problems of inclusion and equality that cross lines that are drawn by statutes and trying to work around that. And of course, doing so in a way that experiments, and I think this is really her focus in her remarks, experiments with non-traditional modes of prompting changes in behavior. But I also found this paper very provocative from a different angle, that of process and more specifically democratic engagement. So what I want to do is focus my comments on those issues. So as Professor Johnson said, a lot of the regulatory approaches that agencies in this space are working on are innovative departures from top-down regulation. So she calls out, for example, the use of carrots rather than sticks. But I want to suggest that they struck me as departures from top-down regulation in a different way. The topic's a little fraught at the moment, and we're not just talking about technocrats for justice, though I have to say I love that. A key justification for agency power, of course, over regulatory policy is that agencies report to the president and we elect the president. Therefore, we can say that agency decisions are more likely to be democratically accountable and are more likely to be responsive. And so this is a top-down notion of democratic legitimacy, both for regulatory priority setting and for particular agency policy choices. So this kind of statement, this kind of justification is always troublesome, given that lots of issues that agencies address are not exactly salient to a presidential election. So maybe voters aren't really expressing their preferences on the nuances of grants versus ex post enforcement, and it might even be a little more fraught at the moment, given the amount of controversy over this presidential transition and the tension between the White House and whether you call them technocrats for justice or you call them rank and file in the agencies. It's a little fraught. But a particularly interesting aspect of Professor Johnson's paper is I think it shows agencies experimenting with and building a more horizontal approach to public engagement and dialogue, building capacity for deliberation outside this relationship between voters, president, and agencies. And I think that's just really interesting. I actually thought as I was reading it, she's talking about, among other things, of course, agencies building mini laboratories of democracy. And I think that's worth at least thinking about. So I think there are three aspects to this that the paper calls out or could call out more. And so I want to highlight them and then just comment on them again very quickly. One is many of these agency initiatives can be seen as building capacity for institutional self-analysis, institutional reflection. So let me just call out a couple of examples from the paper. The HUD affirmatively furthering fair housing rule calls for communities that get HUD financial assistance to self-assess what's going on in their communities in terms of fair housing, what might be contributing factors to housing discrimination in their jurisdictions and the regions. Labor Department requirements for government contractors call for contractors to do self-analysis of workplace equal opportunity. And of course, in the Title IX setting, whether deliberate or not, the Title IX guidances on sexual harassment and sexual assaults are prompting academic institutions to do a great deal of discussion and deliberation. Now, some might prefer agencies to issue a more directive set of requirements from the top down, but certainly these kinds of requirements coming out of the agencies might be prompting entities to engage very seriously and on these equality, on these inclusion issues, and even to reflect on less noticed factors that the agencies aren't noticing that might be causing problems. So that's one piece, institutional self-analysis. Another is experimentation. So of course she talks about grants that encourage experimentation, grants that ask localities, for example, to figure out methods to address fines that have an enormous impact on the poor. And so of course, in doing this, in experimenting, localities are not just looking at the practicalities of how to change their processes, but also learning about the distinctive problems, perhaps in their communities, reflecting on the distinctive problems around finding the poor and around problems facing the poor more generally. The third piece I'll call out, I think, is participation in these institutions. So under the affirmatively furthering fair housing rules, as I understand them, state and local governments don't just decide questions, don't just experiment, they also have to engage with community groups and citizens. And of course, in the Title IX example, again, campus institutions are engaging with a wide range of individuals and groups with something at stake. There's an enormous dialogue going on here, and I think we can see agencies in these settings as prompting that kind of deliberation taking place in these institutional levels and at these local levels. So this is the kind of horizontal engagement I think that's worth some focus. I want to draw a contrast here. Agencies have long engaged in notice and comment rulemaking at the federal level. And notice and comment rulemaking has been praised as a possibly horizontal form of public engagement because it's about agencies talking directly to citizens. But it's quite different. Certainly, there are lots of opportunities for the individual citizen to type up a comment and upload it on regulations.gov. And of course, agencies are putting putting issues on the agenda by using notice and comment rulemaking. But in rulemaking, we don't see agencies necessarily trying to engage particular underrepresented groups in that process, and we don't necessarily see agencies trying to ensure that participants in this process are well-informed or thoughtful or engaged before they submit the comments to the agencies. So I think what Professor Johnson's paper is so interesting in lots of ways, but for purposes of this minute, I think it's particularly interesting because it draws attention to policy experimentation by agencies that can prompt institutions, can prompt local governments to run their own processes and to build their own greater deliberative capacity, and then on occasion to figure out their own solutions. So again, I think this mini labs of democracy is what I liked about this about these examples that she puts together in the paper. Now, of course, there could be benefits and risks here. There could certainly be benefits for federal agencies if they learn more from more thorough processes in all these different settings and design policies that are more responsive to issues raised in them. And of course, there are benefits in general to the country for developing more deliberative capacity in new locations and on new issues. Of course, there seem to be possible risks here. If the programs don't work well, or the participants aren't adequately responsive, and during the discussion section or the discussion period, I'm sure people will have more to add to this. Johnson herself expresses a significant worry in her paper that if we rely too much on very localized decision-making, a jurisdiction might choose, as she says, to do the bare minimum in the service of equality, and eventually we might worry about relying too heavily on a system that allows a race to the bottom or brings us down to the least common denominator. But these questions at least seem worth some considering, and maybe the paper gives us some cause for optimism in addition to a wonderful opportunity to reflect on these kinds of questions. Anyway, thank you for the opportunity to comment, and I look forward to the discussion. Thanks.
All right, these are absolutely wonderful presentations as well as comments. Let me just give you all just a quick opportunity if there's questions in common that you want to raise. I'm very tempted to take the moderator's prerogative, but I'm going to resist, which I don't usually do. But so I'm going to just give you an opportunity. Is there anything that you want to raise? And then I want to open it up just to make sure that we have time to fully address all of the questions that are raised here.
I'm happy to just start with questions. Do you want to?
Well, I just wanted to say thank you. It's always really helpful when people read your work and then emphasize things that in some ways you hadn't fully seen, okay? And so one aspect of it that's particularly helpful for me is the kind of toggling between layers of government, right? I hadn't completely thought of this as a way to build state and local capacity and connected it to, the last time I was at Duke, the paper that I actually gave was on state and local civil rights innovation. And I definitely saw that this part of it was, kind of feeding up from localities, but the idea of sort of increasing their capacity to actually think about inclusion more systematically seems to be an obvious point that I had, but I hadn't fully connected it. So that's particularly helpful. Thank you.
Anything else? All right. Questions? Eloise.
So, Olatunde, I wanted to talk a little bit more about the competitive grant stuff that you raised, and just sort of an observation and then well, maybe just an observation. But so the observation is that one difference between the competitive grant world and the guidance world or other world is that the competitive grant world depends on other institutions like Congress to fund them. So agencies don't just have a pot of money that they get to just decide what they want to do with, but the competitive grants are largely, have to be appropriated and to some extent are designed even in statute. And then the president's budget, maybe the president is proposing it, but it's the president's budget who says, hey, here's this great new thing I want to do. So that could either give us cause for, concern at the moment, but also could let us look ahead to another moment where new programs might get funded and designed by a new Congress that might then actually make the agencies implement a grant program. So just to observe that some of the innovations that look sort of like agency action may not entirely only be agency-driven action. They may end up being action that could be driven by another institution like Congress here in the hands of even a recalcitrant agency if there's a clearly specified, you must do this, here's a long, lengthy set of details that you need to do by this time with this oversight. So there's a little more play in the joints there if you want to think about it that way. In contrast to some of the more guidance-y things that agencies could just do.
I'll just say that's helpful. I think some of these examples are I think most of the examples were driven by the president and the agencies. And they were the ones who put those in. Some of them are asked for, I may could spell that out more, some of them are asked for specifically in appropriations, but some of it may be playing with money that was actually allocated for slightly different purposes, and that's a little bit fudged in the current draft. And I think it's something that's important to look at, is whose priorities are there, and how and who do we want to be involved in kind of setting out the boundaries of this? I mean, is it appropriate that it mostly comes from the agencies, or do we want, as a normative matter, Congress to play a role?
You had looking through the president's budget document.
Yes.
And the congressional justification that the different agencies submit, so you can sort of check the reading and see
who did it. Okay, thank you for that.
So I also wanted to welcome everyone to Duke. I'm sorry about the weather, but rest assured it'll be 72 on Monday. Or maybe it's Tuesday, but it will be soon. Yeah, it's Monday 63. Okay. I had a small point for Nina, just because I can't help myself every time I hear it, and then a more substantive question for Kris. So when you were talking about the problems with the top-down model, right? We elect the president, but it may not be the reasons we elected the president, right? That assumes the president actually, who you call him we, right? That assumes the president's elected by a majority of the people, and right. I can give you 3 million reasons why that's wrong, but you hear it all the time, that there is this claim of democratic legitimacy that simply, as a matter of fact, does not exist.
That's a really strong statement.
Yeah. Do you want me to answer that, or?
Sure. I did want to ask Kris something as well, but sure.
Go ahead. Oh, okay. So yes, of course. It's a formal model, right? The formal model more or less says we elect the president even under, if you will, the most sort of optimistic or consensus or a time where there's the most consensus among the American public. There's no president that's ever won all the votes. So we're always talking about a diversity of views among the American public, and the president's never going to represent everybody's views. The best we can say is we have a process for choosing this person, and really the question is, if the agencies don't receive democratic legitimacy through the office of the presidential election, where are they going to receive it? And I think there are other arguments that can be made about that. One of the reasons why I think Professor Johnson's paper is great is because it does focus your attention, one of many reasons why it's a great paper, it does focus your attention on lots of different pathways by which people might register their views into the administrative state. Yeah, I think the presidential election is a limited form of transmission of views, but it's not meaningless. It's never meaningless, even if it's contested.
Now I realize that we have a substantive disagreement. You just weren't misspeaking, because I think we're never going to have unanimity. But
Correct.
the fact that we're never going to have unanimity doesn't mean there isn't a significant difference between a majority and the loser having a majority. Right, I don't think there's simply points along the spectrum. I think it's central, right, to democratic political morality that when rights are not at stake, it actually makes a difference whether or not you represent a majority at the time of the election or not. That just
I mean, I don't know how far afield the organizers want to take this, although I think I think these are all great sets of questions, and then the question is, how much do we think the Constitution matters in defining our mode of presidential selection? Because it allows for the selection of a president without a straight-up majority nationwide, and there are lots of arguments that we should I'm so not in a position to talk about the Electoral College, but that's the issue that you're raising, right? And I think the question about democracy in the administrative state, I'll just stop at this point, but I think the question about democracy in the administrative state is a real question. The presidential election has been a focus of it. We need to talk about other ways that the administrative state engages the public and is adequately responsive to it. I'm not sure notice and comment rulemaking is a great substitute. It's a supplement, and maybe it just calls out the lots of different ways in which we need to be building pathways between policy as set in the regulatory state and the views of the public. Okay.
Any questions for Kris?
I think you have too much time already.
No, please. I'd like to.
I realize you're doing a history. You're not litigating equal protection cases, let alone the case pending before the court. I do wonder, though, right, if the court, which is where I think it's heading, is going to find a constitutional violation, does your history have anything to say about what the remedy should be, right? Whether it should be as hard for the citizen mother, right, or whether it should be as easy for the citizen father, or does it matter at all? Because you seem to suggest at the end that, right, the congressional bureaucratic intervention is not going to end. So might it be that Congress is going to simply correct if the court is too generous?
So let me spin this out a little bit, since you're more familiar with the litigation than I think probably everybody, but maybe two other people in the room are. So this is the case Lynch versus Morales-Santana, which is currently pending before the Supreme Court. And I've made an assertion that I think you're responding to the assertion that I make, that this is likely to go to Congress regardless of, even if the court strikes down this particular provision as unconstitutional under gender equal protection. And I agree with you that based on oral argument, I actually think the court might do that, including Kennedy. I mean, there's so many variables up in the air. I mean, it would have to include Kennedy, obviously, at this point. There is, the court actually certified two questions in this case. It certified a question regarding equal protection under the Fifth Amendment. Is the gender discrimination in this derivative citizenship statute that is more solicitous, specifically towards unwed mother or unmarried mothers and their children than fathers? Is that a violation of equal protection? And then they certified a second question, which has frankly been lingering for the last, not even just in these cases, but predating these cases, starting with Miller versus Albright in 1998, this question of remedy. So the remedies question, which was certified in the case, is can the court, if there's an equal protection violation, can a court, not just the Supreme Court, but can a federal court, an Article III court, quote unquote, this is phrased by the Solicitor General's office, who's opposing the equal protection challenge at this point, just make sure you get that, the Obama Solicitor General's office, okay? As did the Bush administrations, as did the Bill Clinton administration. There never was a Hillary Clinton administration. I guess I need to make that caveat. Okay. So the question is, can a court, quote, confer citizenship as a remedy? And so this is just to describe the doctrinal legal issue we're talking about. And there's some reason to suspect that even if the court finds an equal protection violation, there will still be an ongoing question regarding remedies, which is a pretty significant sort of federal courts question, frankly, about power of Article III courts in the remedial domain. And so my suggestion that this issue may go to Congress was my sense, having watched this case very carefully and been at oral arguments, that that the court may very well find that there's a violation, but then find that there's limits as to what the court can do with respect to the remedy. And especially Kagan was suggesting that the court might grant an interim remedy of some sort. I mean, I'd have to, it was oral argument, so you're not sure exactly what you're saying, but, and then refer the question to Congress to remedy the issue, which on November 8th did not seem like such a problem. And maybe on November 7th. On November 9th opened up a very different prospect. Because what Congress, or frankly the court could, well, I'm not sure actually the court can do it, but the Congress could, in some respects, do what's called leveling down. It could simply take the rule that's applied to fathers and apply it to mothers, so to speak, in which case mothers' children would be subject to the same standards. This would remedy in a sort of, not in an anti-subordination sense, but in a classification sense, would remedy the equal protection violation, right? So this is, and so your question to me is, does the history that I've provided say anything along these lines? I mean, there's a lot of assumptions that would have to go into it, but I think, not necessarily in this paper, but in other work I've built, I think the history that I've found, and honestly, candidly, sometimes very surprised by what I've found, would suggest that the court or the Congress or whomever, whatever decision maker, the agencies, in their drafting of a new statute or regs for this, would need to level up because of a history of subordination that's embedded in this system of the sex-based classifications. That these aren't simply just classifications, that there is a deep social history behind them, one that's frankly very bound up in our history of racial exclusion in citizenship and immigration. And that would counsel, I mean, one could develop an argument that would counsel towards a requirement of leveling up. There are other problems with leveling down, which are much more technical with respect to for example, if you level down for the class of individuals who are subject to the 1952 version of the statute, if you level down in this case, it would require denationalization of all the children born to unmarried mothers outside of the United States, unmarried American mothers outside of the United States. Congress cannot do that. There's a lot of Supreme Court case law saying Congress cannot denationalize, and this would clearly run afoul of those cases, and Kennedy actually suggested as much off the cuff on the bench. So nobody is suggesting that Congress can do that. The court can't really do that, so there's a bind, right? So there's a question about that you're asking about whether anything I've said counsels one way or another with respect to the remedy. I think it does. One would have to make certain arguments, and certainly somebody with a different jurisprudential philosophy than mine could counter that, and it would be subject to debate. But there's other reasons actually where leveling down, I'm trying to say technical reasons with respect to citizenship per se, that make that impossible, basically.
Yeah, so this is for Olatunde. How much of what you're describing is something that's affirmatively good and something we would do in an ideal world, and how much of it is just a response to constraints? So I think about affirmatively furthering fair housing, and look, there are political constraints to any hard regulation in this area, as George Romney found out when he actually tried to enforce inclusionary stuff in the suburbs. And there are constitutional constraints to doing what I think would be the right thing to do. I mean, constitutional doctrinal constraints, which would just be to say, look, we really care about results. Results defined significantly in racial terms, and let's figure out whether you're doing what you need to do to get to those results. We measure it by numbers. We're not allowed to do that. By 9 Supreme Court justices probably would say you can't do that once we have 9 Supreme Court justices. So we do this softer thing, affirmatively furthering fair housing, and it's got all this language that's, as you say, very, very current of the times. It's it's disruptive, it's information-based, it's all this stuff. But, at the end of the day, is that just the best we can do? Given that the basic problem for many places with housing, and I could do this with some of your other examples too, although housing, it encapsulates as well. Given that the basic problem in many places is, people don't want to live with people who are poorer or of a different color than they are. It's not that they don't know about the impediments. How is this? What's the affirmative case for what's going on in an ideal world as opposed to just given the constraints? Given the constraints, I see the argument for it, which is, it provides levers for people who are arguing for inclusionary stuff. It provides evidence in lawsuits. I mean, that to me, as a litigator, that's the biggest thing. Is they go through this whole process. They get all this information. The information builds a case for intentional discrimination, but also a disparate impact case for people. Lots of people in disparate impact for housing cases use the old analysis of impediments that was required to be done by regs. But aside from those second best things, can you make a first best case for it?
Yeah, I think you've highlighted all the issues, and I've actually thought about this a lot, so you think I'd have a crisper answer. But I think it's both, right? It's both. Sort of, there are ways in which you can justify this as not quite first best, but you can see some advantages I'll talk about in a second. But a lot of it is just the best that we can get under the situation. Okay, so one of the ways you would make it better, and let me just back up for a second. Affirmatively furthering fair housing, one of the things to know about it is that it's a statutory requirement. Because there's been just some idea that HUD pulled it out of thin air. It was a response to the fact that that the federal government promoted and helped instantiate segregation in all of its programs and in sort of urban areas generally, urban-suburban divide, a huge responsibility of the federal government. So it's a statutory requirement, never well implemented. Courts were the main avenue of implementation. And fitfully, but big case in the 2000s, after 2008, 2010, I guess we are with Westchester, something like that. And then HUD revises the regulations and makes them meatier. And they're just an interesting example of the problem that I'm trying to highlight, right? Because from the vantage point of a lot of groups, they go too far, right? Some of you might have seen that Ben Carson said use them and other parts of the HUD regulations as sort of an example of how the department was engaging in overreach. It's very common to call them social engineering or socialism. And my view of it is as long as federal funds are going out of the door, they can't go out of the federal door in ways that promote segregation, right? That's there as a statutory mandate, and for all sorts of policy reasons, is just better for inclusion and democracy and economic well-being and things like that. But civil rights groups have said that they're too fuzzy. They're not directive enough. They don't have a list of some of the best practices that we know diminish segregation, and that you could have a laundry list of things that no locality should have in order to receive federal funds, like you can't discriminate based on source of income, or there's a lot we already know. You have to have an inclusionary zoning program, and it could be much more directive in that way. So the long answer is that I do think it's second best in two ways. One, in that it doesn't have a laundry list. It doesn't have a list of some of the key things. It doesn't have to be a laundry list, but like 5 lists, 5 things that we know would promote integration, and you have to do it, or you can't take federal funds. and it could have more of a requirement of what you alluded to, which was results, that it doesn't matter exactly how you do it. You can maybe do it in a different way, but we have to see progress or you're not going to keep getting federal money. The problem is that since no one has to take community development block grants, there's some jurisdictions, other than big urban jurisdictions, no one would do it. And no one would take the money, so that's a problem. And then politically and constitutionally, it may present a problem. Although I think there's more constitutional arguments. But my best case for it is that as a matter of politics, we actually don't know what promotes how to achieve integration. So we may know what you're supposed to do, like the list of things that empirically in the abstract world seem to make a difference. But it's a matter of building consensus, which is a lot of the deliberation that actually the rule requires. We don't know how to do that, and we don't have a lot of good examples of doing that, and it's prescribing certain processes that might get you there. And so that's my best case scenario for it. I don't mean it to sound like so naive, but I do think that it's important in jurisdictions that want to promote integration or diminish segregation, like in New York, it's very contested how to actually do that on the ground. And that's part of it's ascribing of those processes, I think, is important and necessary and can't be prescribed by the federal government because we actually don't know how to do that.
Take another question or two? Yes.
So, part of what's happened since the election is that we've all been taking a look at these regulatory tools and thinking about how they may be used in a very different way than we've been accustomed to seeing them be used. And so I wondered, with the project of creating mini laboratories of democracy or of creating mechanisms for institutional self-analysis, how do you think about the risk of how those tools may be used in this administration? So, for instance, creating grants conditional on communities coming up with ways to increase the hiring of American-born workers, or creating grants conditional on businesses, so grants that are intended to increase stakeholders' support of deregulation or regulatory rollbacks. How do you, and obviously you can multiply these examples by however you picture the political priorities of this administration would be, but is this mechanism of regulation a good one, regardless of its outcomes, or can its worth only be assessed by reference to the results that it ultimately produces?
Yeah. I mean, I think that, that's the question that made me just sort of sit and, and ponder it for a month with the Duke Law Review. I was like, should I write this or should I not? And I mean that just to say that in a good way. I mean, I come from the civil rights perspective more than from the administrative law perspective, right? So I often don't have to think about the trans-substantive impact of anything that I'm talking about, right? But that's not what a scholar should say, really, right? I mean, and so the good thing about this moment is that it does force you to really think about that, right? And to think about the question that you posed, is what about this is just because I think it's a nice way of achieving these substantive ends, right? My answer to some of this is that, we are constrained by, it's not that there are no constraints. I mean, besides the sort of democratic, maybe imperfect political constraint question, I mean, these are constrained by statutes, and they are constrained by the agency mission. And those are important constraints. I mean, they're not, and I thought that before, right? I mean, because they're huge, and I understand that there's still a lot of room within that, within Title IX, or within, to figure out what something like sex means, or how far you can go in sexual assault. I mean, there are going to be debates on this, and that's why I don't completely take a position on whether or not, for example, some of the interpretations I think are right or wrong. I think it's worthwhile to have these debates about the limits and the substance. And they've always attended civil rights agencies, no matter what they've done. In fact, I actually think that civil rights agencies are usually quite hamstrung by challenges to their processes and their interpretations of the statutes in ways that are, I just think they've always been there, and I find them excessive and actually not really faithful to some of the open-endedness of the statutes. There's been a huge skepticism of federal power. So I think, I mean, I think some of these, I've been forced to examine, how much discretion do you really, and other people, I'd love to have other people weigh in on this, how much discretion you really want agencies to have in general, but I do think that there are, in all of this, that there are constraints. I mean, there have to be. I was concerned about them before, and obviously I'm even more concerned about them now when I think about what agencies could do. I usually think that the instinct in the civil rights area is to overly constrain civil rights agencies, and they usually do nothing as a result.
Are you done? Can I also ask the rest of you to weigh in on this question? I was particularly struck by, to take off from your comments, Kerry, on the role of culture, and also Kris thinking through these administrators making certain sets of decisions. And if we want to think about the question of constraint, Nina brought up the question of accountability, right? Sort of what are these other considerations like partisanship, like culture, ideology, right? Because these administrators are not operating in a vacuum. All right, so you talked about the role that culture plays in creating, it seems to be a mutually reinforcing aspect of it. So I wonder if each of you might pick up on the question and offer us, I guess, your final views before this panel ends on this question of constraint and the looming question, too, of partisanship.
So my reaction to the question was that, yes, it's quite possible that a very different administration could use these tools in a different way, but that we also have to think about two other things. And one is the tendencies of some administrations versus others to even want to use these kinds of tools. So how pro-regulatory is the administration, right? And then the other is, what kind of residue do you continue to get when you've had 8 years of a particular type of governance, right? So it's not as if we have administration A that's going to use all of these tools that Olatunde's been putting forward for us to reach certain ends, and now we have administration B that's going to use exactly the same tools to do something else. They might do that in some contexts, but I think a lot of what we're going to see is a breaking down of using those tools at all, if the promise of deregulation is real, right? So then the question becomes, what happens to these systems that have become built up, right? So I'm taking off the law professor hat now, I'm putting on the university administrator hat, as someone who helped draft our Title IX policy when my university was under investigation by OCR and has now been implementing it over the last year. I'll be very interested to see what happens with a new administration. I was not expecting to see I'm not expecting to see a new Dear Colleague letter that then tells us to do something else, right? That could happen. Like, it hadn't really occurred to me it could happen until Mila started talking, right? That could happen. But what I'm expecting is a rollback of a lot of what happened. And then I'm expecting my university to look at what we've got and say, what do we like about what we have now? Like, what do we want to keep, even though we no longer have to? And what did we do only because we had to? And I suspect some of both, right? But when you were talking earlier, Olatunde, about the community conversation and then Anina's response, I was thinking, yeah, we've had that conversation now. It's good that we had the conversation. There were some unfortunate things about the way everything happened that we probably ended up with some things in our policy we wouldn't have chosen to have. But I doubt that we're going to just drop it all. So the regulation that happened before has now changed what's happening on the ground in the regulated in a way that even an administration change can't totally undo.
It's very useful.
So I am not even sure how I want to respond to Mila's question. I think that's just such a central question for institutional design generally, and even more broadly for the structure of our democracy. How do we judge a program, whether it's by the process it sets up or by the results you get? And it really just underscores that. I actually think it underscores our need to focus on processes as processes, like processes in the right hands the hands that we agree with often get us results that we like, but we do need to take a step back and think about how processes might work if people participating in them have very different views. And no process is perfect. Somebody more erudite than me is going to know exactly what this quote is, but it's democracy is the worst form of government, except that every other form is worse. What's the right quote? Thank you. All right. Thank you. All right, great. So I'm so glad to be here. Anyway, I think these are really important questions, and in some ways, the Obama administration, I think, slimmed down some procedures we were used to, like transparency and tolerating whistleblowers, in the service of getting a lot done to respond to the people who voted for the Obama administration. But I think that's left us a legacy of maybe a little less process. I personally am a believer in the redemptive value of process, the redemptive value of giving reasons, thinking, interacting as, in general, a good system. But I have to say, I'm sure there could be evidence that it doesn't always work in ways that we might think of as productive. And I was reminded of an article, I think it's by Jake Gerson and Matt Stevenson, called Over Accountability, which is about a little too much democratic responsiveness. And so I think all of these issues are really well worth considering. So I guess I'll just end up by saying I think it's a great question.
Kris, you get the last word.
Yeah, so real quickly, I would say the process question, is there a trans-substantive vision of administrative power? And I don't come from the administrative law world, although I do fed courts, so I think about process, and they were obsessive about process, the federal courts folks, and are. But I personally, my own view, since I spend a lot of time in the weeds, I don't necessarily think, and also thinking of questions from an historical perspective, I don't think we're going to have a trans-substantive answer to the question of an ideal agency process, just as along with as we don't in federal courts world either. And on the culture question, I don't think one can't escape culture, one can't escape ideology. So the notion that we would be able to, it's sort of like, I think, the law professor's fantasy that we'll be able to provide the perfect architecture that will serve all purposes at all times. I simply don't think such a thing exists, which isn't to say that I think that democratic accountability isn't important, and that there are some processes that tend to serve us better across time, but that if we're just going to rely on process, we may be in trouble. That said, in terms of one of the sort of process-based values that has been articulated is transparency. And the importance of transparency. And one of the great things about working historically is that I have access to records predating 1925. After that, I need to get security and privacy clearance. So my archive is limited by what I have access to. And so people working today, I feel sorry for you. You don't have access to those processes, the records of how processes are actually made. But I think, regardless of the limits of the particular archive that you're working on, if it's the modern day of the modern world, one thing we can do as academics right now, I think, and this is what I say to myself as I go to my computer every day to think that I'm doing something that's helpful, is to insist on transparency as much as we can, is to insist on some version of the truth that seems grounded in reality. And to bear witness to that as much as we can in our particular fields, and to make that record in the law reviews, right? And in whatever domain, on the blogs, whatever we can do. And that's a process value, right? So to the extent that I'm cynical that we might be able to provide a perfect architecture that's going to lead us through an uncertain time, I do think there are things we can do.
Well, they were as advertised. Let's thank them. Thank you so much.